We will get started now. Welcome everyone to the 2023 New Laws Encore presentation with Gov Hutchinson. We're very lucky to have this accomplished speaker with us here today to hear about all the 2023 new laws impacting the real estate industry. I'm Brian Zutel, the 2023 chair of the Orange County Risk Management Committee. Let's give a big welcome to any OC Realtor officers or directors that we may have in the audience. Thank you for your service and your service to this association. At this time, I want to make sure that you know that this presentation is being recorded. We will have an opportunity to ask any questions of Gov. So if you do have questions, please use the Q&A function in Zoom to ask those questions. Do not use the chat function. We'll be monitoring the Q&A function and we'll try to get all of your questions answered after Gov's initial presentation. Before we begin, let's take a moment to salute our great flag led by Vice Chair Gina Sander.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let me take a minute to thank our sponsors of this event: Accurate Termite and Pest Control, Golden One Credit Union, New American Funding, and Reverse Mortgage Educators. Thank you for your sponsorship in making this event possible. Now, I did a little research before our event today. Last year, Governor Newsom signed almost 1,000 bills into law. Almost 1,000 bills. Can you imagine if Gov had to explain all of those various bills? But we are greatly benefited by Gov and the rest of the legal team at CAR, who will scour through those laws, who will determine which ones affect the real estate industry, and will help update us as to those that we should be aware of. So we're very fortunate and blessed to be able to hear from our presenter today, who needs little introduction, Gov Hutchinson, Vice President and Assistant General Counsel of the California Association of Realtors. Welcome, Gov.
Thank you, Brian. Thanks, everybody. Good to see you virtually. I'm actually in Laguna Hills today at your very own association office. For those of you who showed up on Thursday, I am so sorry. I missed that. I think it's the first time in 30 some years I actually sort of missed something. And I'll try to make it up to you any way I can. I'm glad you're back today for this update. I'm glad this is recorded in case, because I talk kind of fast sometimes and I cover a lot of stuff. And you can always, I invite anyone who has a question that I don't get to today. Of course, you can call the legal hotline, 213-739-8282. But you're welcome to email me, govh@car.org, govh@car.org. I actually, believe it or not, respond to every email eventually. So feel free. As Brian said, he was exactly right. The governor signed 997 laws this year, maybe 30 related to real estate. And we have a handout on our website that you can access anytime, 2023 new laws. I'm really only going to talk about 10 because there's only about 10 I think really even worth mentioning. But I'm also going to spend some time this afternoon talking about form changes, which are very important. I think almost more important than the law changes this particular go-round. So we'll cover new forms and new laws, and we'll take about an hour to do it. So let me just get started. But another thing, by the way, as we said, 997 new laws, but a lot of laws get proposed that don't actually get to the governor's desk. And one of CAR's most important functions is to make sure the bad laws don't get to the governor's desk. We had a very good year last year. There were all sorts of terrible bills like, if you sold the house within 3 years, you had to pay a 25% tax. There was a bill that was said if you had a tenant in your property, you had to first offer it to the tenant before you could sell it to someone else, and you have to wait a couple months before you could sell it. There was a law that said landlords were going to have to respond in writing on a questionnaire anytime they rejected a tenant for certain reasons. More rent control, mandatory energy efficiency audits anytime you had a rental property, an audit of every house in California for the cooling system. All sorts of bad things didn't get passed. So it's actually a good year for new laws in that the laws that did get passed you're not gonna find really objectionable. There's only one that's fairly controversial, but I'll get into that. So let's talk about them. First law, there's only one law that Valerie, govh at car.org, govh@car.org. There's one law affecting you directly, and that is AB 2745, deals with licensing. Do you know before you can take a broker's exam, you have to be licensed as an agent for 2 years first? The change in the law is that those 2 years have to be within the last 5. So someone who was an agent several years, 10 years ago for many years, and then they dropped out of the business, and now they want to come back to the business and be a broker this time, not so fast. They got to be an agent again for 2 years. It's always 2 of the last 5 before you take the broker's test. The only other one concerning broker licensing was a new law last year, took effect this year, which says when you renew your license as part of your 45 hours, there's going to be a new class concerning what's called implicit bias. And the fair housing class is going to be bigger, and it's actually going to have a role-playing component you're going to have to do. It's still 45 hours, but they're slightly different this year. Okay? All right. Second area of laws, landlord-tenant. There are a lot of bad laws that didn't get passed, but only a couple worth mentioning that did get passed. Before I go any further, though, just general comment. Some of you might be property managers. Some of you just do lease listings sometimes. Some of you never do lease listings or property management, but you have clients with tenants who ask you questions, or maybe you're a landlord yourself. General comment. The landlord-tenant laws in this state are incredibly complicated, and there's also many, many local laws. And it is not your responsibility, unless you are a property manager, to actually be expert in these things. So try to avoid giving advice. When your clients ask you, hey, can I evict this tenant? If so, what form do I use? It's not a simple question. Get them to get legal advice, or you call a hotline. Or they ask you, how much can I increase someone's rent? Answer, it depends. Get advice. I'll give you the big picture. On February 3rd, the governor terminated all 26 existing California states of emergency, but there's still the California COVID state of emergency until the end of February, which means the entire state is still under, the conservative look is the entire state is still under the California anti-rent gouging laws, which means you can't increase the rent by more than 10%. Now, some people think that since the governor ended the 26 other states of emergency, and some attorneys are saying, well, that means you can increase the rent by more than 10% now. We're not 100% sure. If you want to be totally conservative, I wouldn't increase a tenant's rent by more than 10% until the end of February. You might be able to do it now. CAA, California Apartment Association, thinks you can. I'm a little more conservative. I would wait, but not necessarily. Also, remember, under California rent control, if you got a rental property more than 15 years old, 3 or more units, or a duplex that's not owner occupied, you're limited by California rent control as to how much you can increase someone's rent. This year's number on that is exactly 10%, same as the anti-rent gouging laws. And if you live in a certain city like LA, or I don't know about Santa Ana, other cities have other requirements. It's complicated. Get advice before you help people do it. Same thing with evictions. It's still a little bit complicated, especially if you're in LA County or LA City. All right. 2 laws affecting rentals you might find interesting. One is AB 2559. There's a new thing called a reusable tenant screening report. Landlord has a vacancy. Tenant wants to live there. Landlord can say to the applicant, I need to charge you a fee to screen you. There's a law that fee can only be a certain amount. It goes up by inflation every year. Last year, believe it or not, it was exactly $52.46. This year, it'll probably be like $60. The point is, tenants now have the ability to go to a consumer screening agency, anything from Rent Spree, et cetera, and then get a full-fledged certified screening report with eviction history and rental history and all that stuff, income verification, and they can use it more than once. They can use it with different landlords as many times as they want over a 30-day period without being charged each time. Of course, landlords don't have to take this. Landlords can say, no, I'd rather charge you, get my own screening report through you. They can do that, but we're hoping landlords, since this is a certified report, it'll probably streamline the process. Maybe they'll use it, maybe they won't. They don't have to, but it's a new thing. The second new thing on rentals is deals with domestic violence in a rental situation. And I don't remember the I'm sorry, I don't remember the bill number right now, but here's the deal. The old law, and by the way, all these laws took effect January 1st. The old law says if there's domestic violence going on in a rental, the landlord finds out about it, they can evict everybody. Or the tenant has the right to actually terminate a lease themselves. Tenant can say, you know, I'm suffering of domestic violence. I need to get out of my lease. I know I have 6 months left. You need to let me go now without losing my deposit, without losing anything, and without it going on my record as a termination. And landlords have to allow that. Here's the new law. The new law says tenants can still terminate a lease on their own if they're a victim of domestic violence. However, number one, landlords cannot terminate the whole tenancy if the tenant doesn't want that. And the tenant who's the alleged victim of domestic violence can say to the landlord, domestic violence is going on here, but I don't want to leave. I want you to kick out the bad person. And the landlord must evict the alleged bad person. Well, what type of proof does the tenant have to come up with to compel the landlord to evict the alleged perpetrator? Answer: either a police report, a restraining order, or any other reasonable documentation from someone who's sort of involved in these matters, like victims advocacy group or something like that. It's a little bit gray. I'm sure there are going to be lawsuits on this to clarify it, but it's a big deal because if you violate this law, landlord, you're fined. You can be fined $5,000. Bottom line, you're in this situation as a landlord or property manager, and the tenant is either saying they want to get out or they want you to kick out the other person. Get a lawyer, get legal advice, call the hotline, and we'll advise you, because it's a new thing. It's going to be challenged. It's controversial, but it's real. You have to evict the alleged perpetrator in certain circumstances and change the locks. I mentioned a second ago, the landlord can't terminate the whole tenancy, kick everybody out, but the landlord can say, and the eviction order can say, hey, tenant, yeah, we just kicked out the bad person, but if you let the bad person back, that's automatic grounds to terminate your tenancy. Plus, you know, it's going to be a hard standard about what are these other groups that can do it, that can provide the proof. And the other issue is, if the landlord believes reasonably that the alleged perpetrator poses a risk not just to the victim tenant, but to other tenants, that gives the landlord the right, the option to terminate the entire tenancy, including the alleged victim. Complicated law, probably the most controversial law that you might run into this year. So if you have any issues, please call us on that. Okay. By the way, we do have a handout. I already mentioned, yeah, on our website, talking about all these laws I'm talking about in detail, plus a few more. Now, there's quite a few new laws I'm not going to talk about today dealing with good news for real estate in trying to eliminate some of the red tape preventing builders from building. Builders will tell you in California, it's hard to build properties. It costs a lot and it takes a long time, and there's a lot of regulations. And there's some movement, there's some new laws that are going to make it a little bit easier. One of them is making it a lot easier to convert commercial space to residential space. You don't need to know the details. They're in our handout if you're interested. But I just want you to be aware that some of those were passed. Let me go on and tell you a few more laws that you might be interested in. Speaking of building housing, There's a new law making it even easier to build accessory dwelling units. And this one is SB 897. Basically, in California, if you own a house, you have the pretty much unfettered right to convert a part of your existing space into a junior accessory dwelling unit. And you can also build an outside separate distinct accessory dwelling. You can basically build a regular one and a junior. When I say you have the right to do it, I mean the city or the county or the HOA has no discretion to simply say no. I mean, if you meet health and safety precautions and follow the building code, they have to allow it. The only restrictions they can make are they can require a setback, and there's a height limitation. Plus, you still got to apply for an ADU approval, even though they don't really have the discretion to approve it, to not approve it if you meet the building code, but it still is a process, and it's been taking too long. New law says any government agency involved in the approval process has to give you an answer within 60 days and tell you exactly what needs to be done to fix it. Second, the setback requirement can't be so big that it effectively prevents you from building it. And third, the height of the ADU can be bigger than it is under current law, which is 16 feet for detached ADUs. Now, detached ADUs that are within half a mile from a transit stop or bus stop, transit corridor, can be 18 feet high. An accessory dwelling unit where you want the pitch of the roof to align with the pitch of the main house can be up to 20 feet high to accommodate that. And if it's an attached ADU, not detached, it can be up to 25 feet high. So ADUs can be bigger, and there should be fewer obstacles to building them. By the way, this is what people are doing now. Remember last year I told you about SB 9? We were all worried that there's going to be this. That was the law that said if you own a single family home, in many circumstances, you can add another unit to it without government wouldn't have discretion to stop you. Plus, in some cases, you could do a lot split and add 2 units on both lots. You could turn your single family home lot into a 4-plex. That's just not happening. In the entire state of California over the last year, there have been like 200 of these. Because there's still a lot of obstacles. Like, HOAs can say absolutely not. Cities and counties can say no in a lot of circumstances. If you're in an earthquake zone, flood zone, fire zone, well, that's half the state, right? Landmark areas, historic areas, protected habitats. There's just a lot of obstacles, and it takes a while. So people really haven't been going that route. People have been going the ADU route, and you can do ADUs, and there's no owner occupancy restriction, and you have the right to rent them out too. So anyway, it's a little bit easier on the whole ADU thing, if you're interested in that. Speaking of building, there's a new law that says, it's AB 916, says, let's say you have a house, and you have a 2-bedroom house, and you want to make your house a 3-bedroom house. Not by adding on, but just by simply, inside the house, reconfiguring, adding a wall or whatever. Local counties and cities have no discretion to say no. I mean, you can, you have to meet the building code once again, but other than that, they can't require a hearing and argue it out. It's pretty much build by right, just like ADUs. Okay. A general new law along these lines, AB 2097, says for all buildings, and this includes ADUs. By the way, if you build an ADU, can the city require that you sort of add a make sure that you provide for an extra parking space? And the answer is yes. Just like generally developers can in general require additional parking spaces. New law says if the property in question, if the parcel in question is within a half a mile, there's that magic half a mile again, the magic half a mile distance from a transit stop or a major transit corridor, which are defined, they cannot require extra parking. I mean, I don't know about anywhere you go, but there's some cities where it's like the biggest thing preventing new construction is the fact that there has to be provisions for new parking. This is affecting a lot of big developments, and this is going to make that a little bit easier. Okay. Homeowner associations. Can an HOA prevent you from renting out your unit? The current rule is HOAs have to allow at least 25% of the unit owners to rent out their property. So if you're in a 100-unit complex and there's only 20 of them that are currently rentals and you want to rent yours, the HOA couldn't stop you. But if there are already 25 or more that are rented, they could stop you. They don't have to. They can allow you to rent them. I mean, there's certain lending guidelines that they're going to follow, but in general, 25% of the rule. The new law says basically, and this is AB 1410, the new law says if you're just going to rent out a portion of your property, in other words, you're still going to live there, you're renting out a portion, that doesn't count towards the 25%. So you pretty much have an absolute right to do that. By the way, now I remember the domestic violence law I mentioned was SB 1017. Okay, anything else laws you should know about? Just a couple. Mobile home park management. So you're dealing with a mobile home park. They have management. At least one person, member of the mobile home park manager, if there's only one person, the mobile home park manager must take a test and pass the test and become certified in mobile home park management. Meaning, and this test is going to test their knowledge of the mobile home laws, the laws that govern mobile home residencies and mobile home parks and all that stuff, and the rules on transferring mobile homes, the rules on evicting people from a mobile home park. So that'll be interesting. It's an annual test. They have to be certified every 2 years, got to take a test once a year, be administered by HCD, Department of Housing and Community Development. Speaking of mobile home parks, there's another law I mentioned last year, but just to remind you, if you live in a mobile home park and you're renting out your mobile, this doesn't apply to you. But if the mobile home being rented out is owned by the mobile home park, so in other words, they don't just own the park, they own the mobile home itself. That mobile home park landlord automatically comes under the California rent control law that I mentioned a while ago. Remember I said that usually applies for rental properties that are 3 or more years old, that are 3 or more units, or duplexes that aren't owner occupied and the building is over 15 years old. This law says, regardless of how old the mobile home is, if it's in a mobile home park and it's owned by the park, the landlord is restricted on how much rent they can charge by the California rent control law, and they're also restricted on the reasons to evict. Remember, if you're not under any rent control law, you don't need a reason to evict. If you're in LA City, pretty much the entire city is going to be under some type of just cause restriction, but in general, single family homes, you don't need a reason to evict. But if you're under California rent control, you do need a reason to evict, and that's why it's important to understand that distinction. All right. Believe it or not, there's only really one more law I really want to tell you about that you need to know. It'll be about 10 or 11 laws I've told you about. It's called the First Look Program, AB 2170. And this is the law that basically deals with REOs. It applies to banks or mortgage servicers that foreclose on properties and then resell them. It only applies to the bigger ones, the institutional ones. You know, mortgage servicing companies that foreclose on 175 a year. If they do that, then they have 2 new restrictions. One of them is when they sell off these REOs, they can only sell them during the first 30 days they're on the market. They can only sell them to owner occupants or certain nonprofits. who sign an affidavit saying, yeah, this property is only going to be sold ultimately to someone who's going to live there. If they wait 30 days, they can sell it to investors, but if they want to sell it within the first 30 days. Second, these mortgage service companies will no longer be able to sell off their REOs in bulk, meaning they can only sell them one by one. Once again, favoring owner occupiers. I mean, if they put on the market 10 REOs at once as a package, you got to buy all 10. I mean, who can buy 10 properties at once? The big institutional investors. And they're not going to be able to, they're still going to be able to buy the single family homes. But once again, for the first 30 days, they can't buy it at all. So we'll see how this all works out as far as, you understand the concept here, make it easier for people who actually want to live in the house to buy these houses. All right. That is really it. That's 10 or 11 laws I really wanted you to know about. I think we'd all agree that a lot of those laws that didn't get passed would have been really bad. But one of the ones that did get passed are bad at all. Maybe the domestic violence one's a little controversial, but that's about it. The big news this year is not new laws. The big news is sort of new forms. So let me go there. First, give big picture. You've probably heard that there is federal litigation going on regarding a couple of things. Regarding the clear cooperation rule. In other words, whether that's legal, that the rule can be that when you put the house on the market, within a day, you have to put it in the MLS. And believe it or not, there are big legal lawsuits involving challenging the entire commission structure of organized real estate. How are commissions paid today, yesterday, your whole life until now, maybe the future? Typically, a seller signs a listing contract with a listing agent, agreeing to pay X amount. And then the listing agent puts that listing in an MLS and offers to share part of their commission with the buyer's agent. It's mandatory that you have to offer compensation to the buyer's agent by doing this. The challenge of these lawsuits is basically saying that whole concept is an antitrust violation, it violates federal law. Buyers should be paying their commissions. Buyers should be paying their agents directly. Sellers should be paying their agents directly. None of this cooperation stuff. It's antitrust. It artificially inflates and commissions, yada, yada, yada. This is a lawsuit against NAR, and it's also against the big franchises, the Remax, Keller Williams of the world, Coldwell Banker, etc. CIR is not involved in this lawsuit, but however these cases come out, it's going to affect everybody. Now, you might have read in the paper, good news was, separate from these lawsuits, the Department of Justice was doing an investigation for a couple of years into the whole clear cooperation and the mandatory submission. Under the previous administration, NAR entered into a settlement. And the settlement was Department of Justice was going to drop its investigation if the realtor community agreed to two things. Number one, making sure the buyer's agent's commission is accessible to the public in the MLS. And you know that's true, right? Today, buyers can go to the MLS on the public remarks. They can see how much commission is being offered the buyer's agent. And the other thing that was agreed to was that buyer's agents would never say their services are free. And that was changed in the Code of Ethics. Then the Department of Justice tried to back out of this under the new administration. There was a recent court case that said, you can't do that. That was a settlement agreement you made. That's a binding agreement. The reason that doesn't make the problem go away is because there are still these private lawsuits. It's not the government, it's private individuals, plaintiffs suing, and they're allowed to do that. They're suing organized real estate under the antitrust laws. I want to make a couple of things clear. These lawsuits have not gone to trial yet. They probably won't go to trial maybe until next year. However they go to trial, they'll be appealed. This will go on for years. So people are saying, oh my God, the world is changing. Buyers have to pay their own agents. No, they don't. If it ever happens, it won't happen for a while. It may never happen. Nothing may ever change. Or buyer broker contracts. I heard they're mandatory. They're not. They may never be. Keep that in the back of your mind when I talk about the forms. Nothing has changed. Nothing has all changed. Anything that you have to do. Having said that, let's talk about new forms, okay? And I'm going to talk about 10 new forms. I talked about 10 new laws. Let's talk about 10 new forms because that's exactly how many new forms there are. Before I talk about buyer broker, let me just talk about a couple forms you're going to deal with. One of them is not required, but it's a good form. It's called the non-contingent offer advisory. You remember probably the market of a few months ago, the intense sellers market we had, where I don't know about in Orange County, but in West LA County, the Bay Area, and I'm sure places in Orange County, the only way a buyer could get an offer in front of a seller was to make it non-contingent. There were so many offers, there was so much competition, you had to make your offer look good, and the buyer would just remove their contingencies right in the middle of the offer. Obviously a risky thing to do, but sometimes you got to do it. Well, guess what's happening now, of course. Months later, the buyers who bought these houses without doing inspections or whatever are now suing their agents, saying, my agent never explained to me the risk of making a non-contingent offer. My agent forced me to make a non-contingent offer. Probably not true, but at least there's now a new form called the Non-Contingent Offer Advisory, Form NCOA, which basically says to the buyer, a non-contingent offer is a risky thing to do. And it explains sort of what you're giving up. You're giving up the loan contingency, you're giving up the inspection contingency and the appraisal contingency. And it basically says, as a broker, I'm recommending you don't do this. In general, you shouldn't make a non-contingent offer unless you talk to your own advisor, like a lawyer, and make sure you understand exactly what you're going to do. I guess in retrospect, it would be nice to, this form had been out a few months ago, but the point is it's out now. You're probably not going to use it now. You're probably in this market not making non-contingent offers. You probably don't need to, but you might in the future, in which case the market will come back. The seller's market will be back. I guarantee that. And maybe non-contingent offers will start happening, and there's a new form that's not required. That's a good form. Okay. Second new form is sort of required, sort of not. I'll explain what I mean by that. It's called the Solar Advisory and Questionnaire. The initials of the form are SOLAR, Solar Advisory and Questionnaire. Now, I said a second ago, contingencies. The buyer has 8 contingencies. Buyers have 8 ways to get out of a deal. I didn't get the loan. It didn't appraise. I don't like the inspections. I don't like the disclosures. I don't like the prelim. I don't like the HOA docs. I don't like the solar lease, or I want to sell my house first. Now, the last one's optional. So your offer may only have 7 contingencies. If there's no HOA docs, you only have 6 contingencies. If there's no solar, you only have 5 contingencies. And if it's all cash, you only got 4 contingencies. So not every offer has all the contingencies. The point is that one of the 8 contingencies basically says, if I'm a buyer and I'm buying a house and there's some part of the house that is not owned by the seller, it's attached, but it's leased, or there's a lien against it. Could be water softening equipment, could be propane tanks. Usually it's sold. So the purchase contract basically says seller has to give the buyer the copy of the solar lease, and the buyer has 17 days to review it or whatever. Well, you know what, in the real world, have you ever seen one of these solar leases? They're like 12 pages long, hard to figure out. The forms committee said, we need to help out the buyers here. So they created a 2-page form that basically says, hey, seller, if there's solar on the house, panels, any type of solar system, whether it's owned or leased, you should give this form to the buyer. The first page of the form just explains to the buyer the general concept of what solar is. How does it work? What's the difference between leasing and owning? And how does the purchase contract contingency work? How does it all work? And on the second page, the seller answers some questions. Is it leased or owned? If it's leased, how long is the lease? If it's owned, how much power is being generated? How long is the lease going to last? What's the monthly payment, et cetera, et cetera? I know what you're saying. Some sellers aren't going to know the answer to these questions off the top of their head. That's fine. It says, are you aware? You know, are you aware? Are you aware? It's just like the SPQ and the TDS. But hopefully sellers will fill this out and it will assist the buyer in deciding whether they want the house with the solar panels on. You still have to give them the whole lease, and the buyer still has 17 days or whatever to figure out if they want to assume it. But I think it's going to be a helpful form. Now, there's a new paragraph in the purchase contract, paragraph 11M, which is part of the disclosure paragraph that talks about this. And I want to point one thing out. This is not required by law. So for 30 years, I've been telling you every disclosure in the disclosure paragraph, remember it used to be paragraph 10, now it's paragraph 11. Every disclosure in that paragraph is a mandatory by law that can't be countered out. This one actually can be countered out. If for some reason the seller doesn't want to fill out this form, they could counter out paragraph 11M and say, I don't want to do it. I don't recommend that, but it's not a legally required form. Remember, there's 5 required forms that give the buyer a 5-day right of rescission: the NHD, the TDS, the seller property questionnaire, the lead paint if it's pre-78, and the fire hardening if it's in a high or very high. And if you're a probate REO, bankruptcy, or trust, you're exempt from the TDS and the SPQ and the NH and the fire hardening, but you have to do the exempt seller disclosure. And then there's other disclosures in that paragraph. You have to do the FERPTA form, the environmental hazards booklet, the earthquake booklet, and the HOA docs. They are required by law. They don't trigger a 5-day right of rescission. So this new one, the solar form, not required by law, obviously no right of rescission, but it's required in the contract. So you'd have to counter it out if you don't want to do it. To be precise, it actually doesn't say that the form is required. It says the disclosure is required and the form is there to use. So theoretically, the seller could make the disclosure about this information about the solar without using the form. Why not use the form that's already there? Okay. All right. So that's one form you're probably going to start using if you're selling property that has solar. Those are 2 forms. Now let me turn to the buyer brokerage form, and I'm also going to talk about the purchase contract. Remember what I just said a second ago? Buyer broker contracts are not required. Period. That might change. There might be a law that gets passed separate from these big lawsuits that requires buyer's agents who are in a relationship with a buyer to document that relationship in writing. It may say to get paid, you have to have some type of buyer broker contract. This hasn't happened. It may never happen. I'm not sure if it will ever happen. Be aware of it. But right now we do have a buyer broker contract. In fact, we have 3 of them, and they've just been combined into one. Okay, so the buyer broker contract, we used to have 3. One was like an exclusive listing where buyer says, if I buy anything in the next X amount of time, you get paid. One was a non-exclusive that says, if you find me a property, I buy it through you, you get paid. And the other one said, I'm your buyer, you're my agent, but there's no monetary agreement. The new form, the BRBC, buyer representation and broker compensation agreement, combines all 3. It defaults to, it's a non-exclusive one that says, if I buy something and you introduce it to me, I'll make sure you get paid X. You can check a box and make it exclusive. Well, what if I don't want it to involve any monetary promise at all? Then you can just put a 0 in the compensation box. Now, I know most of you, I guarantee, even though I'm not seeing you in person, I know most of you don't use buyer broker contracts, which is unusual. Most states, buyers agents usually do use. But the point is, I think one thing to remember is even when you have a buyer broker contract where the buyer has promised, okay, if I buy anything through you in the next, that you introduce me to in the next 6 months, I'll pay you 2.5%. Even then, the buyer rarely has to pay any money, because it says in this form that any commission money that the buyer's agent is receiving from another source is a credit against the amount I owe here. So normally, I think, even if you have a buyer broker contract and your buyer signs it, let's say they promise that, okay, if you help me buy something, I'll make sure you get 2.5%. Ultimately, they end up writing an offer on a listing in the MLS where the listing agent is offering you 2.5 or 3. In that case, the buyer doesn't have to pay anything because the amount of money you promised them, they're getting paid from another source. The only time it ever kicks in is where the buyer has to pay is in, for example, you sign a buyer broker contract where the buyer promises to pay you 2.5%, and they write an offer on an MLS listing where the listing agent is only offering 2. There's a 0.5% gap. Under the buyer broker contract, the buyer would have to pay that money. So it's rare, I think, that you guys even use buyer broker contracts. And even in the rare case when you use them, it's rare that the buyer ends up being responsible to pay. But it is a possibility. And the reason I'm saying that is because the thing that's caused the number one confusion right now, that at least as far as the hotline can tell, is there's a new paragraph on the purchase contract. Paragraph 3G3, which is an optional paragraph. If you check the box, it says seller agrees to pay the obligation of buyer to compensate buyer's broker under separate agreement. Seller's broker's offer is any to compensate buyer's broker is unaffected. You realize that would only be relevant if you had a buyer broker contract and the buyer broker contract was resulting in the buyer having to pay some money. In that situation that we all agree is unusual, the buyer now has the ability to check the box and say, you know something, seller? They're basically saying, I got a buyer broker contract. I promised my agent 2.5% or 3%, and your client, your listing agent only offered my buyer's agent less than that. So there's a difference I have to make up. You know what? I think I want you to pay. It's like asking the seller to pay for a termite report or asking the seller to pay for escrow fees or title fees or transfer taxes. You're asking the seller to pay for something that you would otherwise have to pay yourself. The seller can say no. In fact, you don't even have to ask. Just because you owe your client some money, just because you owe, the buyer owes you some money, doesn't mean they have to ask the seller to pay for it. So I think when you're on the buyer's side, you're very rarely going to check that box. Once again, even if you're in the rare situation where your buyer actually owes you money, that doesn't mean the buyer has to ask for it and the seller can always say no. What I'm hearing though is some of you guys, when you're listing agents, you're getting offers where the buyer's agent has checked that box. Or I've even heard of some offices telling their buyer's agents, you should always check that box. Number one, don't tell your buyer's agent to check the box. It's not necessary. It's just confusing. What if I'm a listing agent and I get an offer from a buyer's agent and they check that box? So you say to them, okay, show me the buyer broker contract that obligates you to pay money. And they say, oh, no, there isn't one. Then why did you check the box? Oh, my broker told me to. Just counter it out. Either let them resubmit the offer or just counter it out. Just say no. People are confused. I understand. And I think I understand the confusion. I think what the Forms Committee is doing here is sort of playing the long game. They're saying, if one day, next year, the year after, all of a sudden the whole world changes and buyers are required to compensate their agents directly out of pocket, buyers are probably at that time going to start asking sellers to do it. Just like you ask sellers to pay for other closing costs, buyers will probably say, I don't want to pay that. I want you to pay. And it'll work out sort of the same way it is today. And remember, this may never happen. Nothing may ever change. But some of you are using buyer broker contracts right now. And this just makes the buyers in an unusual situation, the buyer has the ability to ask the seller to pay for it. Okay? I hope that makes it clearer. So there's another new form that goes along with that that's mentioned in paragraph 3G3 called the SPBB, Seller Payment to Buyer Broker. Obviously, if you're asking the seller to pay the amount of money you owe your buyer, the seller wants to know, well, how much is it? What are you asking me to pay? You check a box telling me to pay it. What are you telling me to pay? That's why you're going to add this new form, the SPBB. So if you're keeping score, the first two forms I told you were the non-contingent offer advisory, never required, not going to use it much now. Second new form is the solar advisory, required by the contract, basically. Third new form is the combined buyer broker contract that combines three forms into one. The fourth brand new form is this SPBB, which you're only going to use if you check that box in paragraph 3G3. Okay. We're also related to buyer brokerage. Remember how I said a second ago how on the MLS now buyers can actually figure out how much money the listing agent is offering the buyer's agent? Leads to another question. Are buyer's agents legally required to tell their buyers how much they're getting paid in this transaction? No. I mean, the buyer can figure it out if they want to, but you don't have to bring it up. Now, that law may change also. That's also being challenged. There's a possibility that the law is going to say, oh, yeah, we have to tell your buyer how much you're getting paid. That may never happen. Don't quote me wrong. That may never happen. But in case it does happen, we got a form already. It's called the ABCD, Anticipated Buyer Compensation Disclosure. This form is not required. But guess what? But think about it. If you're using a buyer broker contract, it is required. I mean, after all, if you're saying to your buyer, you got to pay me the difference between any difference between what you're guaranteeing me and how much I'm getting to the MLS, of course you have to tell your client, if you buy this house here, you're going to have to pay me 0.5% because on this house here, the MLS is only offering me 2.5. But if you buy this house here, they're offering 3, so you're not going to pay me anything. On the other hand, if you buy this house here, they're only offering 1%, you're going to have to pay me even more. So this ABCD form I mentioned is pretty much required if you're using a buyer broker contract where the buyer is promising to pay you. Okay. Couple more forms that you're only going to use if you use buyer broker contracts is there's a new form called the Buyer Transactional Advisory, the BTA. This is actually a good form in general. It basically is just you're talking to your buyer and saying, you know something, I'm your agent, you're my buyer. We should sort of figure out what your responsibilities are, what my responsibilities are, what I'm not going to do, what I am going to do. Now, this is already on the Buyer Inspection Advisory. There's already stuff on this on the Buyer Broker form. There's already stuff about this on the Avid form. But this is a nice, puts it all together on one page, what the duties of a buyer's agent are and the duty of a buyer. So that's a new form, the BTA. 2 more new forms. One interesting change about this buyer broker contract is, unlike the old buyer broker contract and unlike your listing forms, it says either side can cancel at any time. If it's an exclusive buyer broker contract, you have to give 30-day notice. But if it's not exclusive, either side can cancel immediately. One of the reasons it's hard to get a buyer to sign something is because they don't want to commit to you for a period of time. So you say, hey, just sign it. If you don't like me, you can quit in 3 days. But you're still protected because it does say any properties that you introduce to the buyer before it gets canceled or before it expires, if they buy any of those, you still get paid. So there's a new form to put that in writing. It's called the Notice of Broker Involved Properties. So if you have a buyer broker contract and they want to cancel you or just runs out of time, you're going to give them this list of properties that you introduced, which means if they buy any of those over a period of time, you still get paid. So that's a form obviously you need, list of broker involved properties. And the other form is the cancellation of buyer representation. That's COBR. And the other one is NBIP. By the way, I'm talking to you today. I'm cramming all this into like a half hour. We did a 1-hour webinar on just these buyer broker contracts. We did a 1-hour webinar on just the changes to the purchase contract, which I am going to cover in a minute. And we did a 1-hour webinar on changes to our property management forms. If any of you guys do property management, you can get these for free on the website. Look up legal live webinars. If you can't find it, just call the hotline. We'll send it to you. So I just want you to know we have this. This is recorded. I'm glad, but there are other things you can access as well. All right. So that's enough of the buyer broker contracts. Some of you will never use any of these forms. One day you may all use these forms. Who knows? I don't predict the future. Whatever it is, it's not going to happen soon. A couple more things to remember, though, and this is important. Let's say you don't have a buyer broker contract, and you're working with a buyer, you're working hard, you find them the perfect property, and then they go write it up with their brother-in-law who just got his license. If you have a buyer broker contract, obviously you can sue them for the money. What if you don't have a buyer broker contract? How are you protected in that circumstance? Well, you can take the brother-in-law to arbitration. You can go to the board of realtors and say, you know, this guy wrote it up and he got paid, but I'm the procuring cause here. I deserve this commission. The only reason this guy dropped me is because he liked his brother-in-law. So you're going directly after, you're not going after the buyer, you're going after the other agent. And that's fine, but you never know how those arbitrations are going to work out. You don't always win. It's not always obvious. Other factors come into play. So that's one reason to have a buyer broker contract. But here's the deal. There are such things called procuring cause guidelines, which is telling the panel of people on the professional standards committee what factors should be taken into account to determine which of the two agents is the procuring cause. There is almost definitely going to be a change to the procuring cause guidelines that are going to say, if two agents are in a dispute over a commission, arguing procuring cause, and one of those agents happens to have a buyer broker contract and the other one doesn't, that should be almost not the definitive, but that should be probably the most important factor to be considered. In other words, they're basically saying the one with the buyer broker form should probably win. Another reason to think about using buyer broker contracts. All right. Okay. To wrap this up, let's talk about the purchase contract changes. This will only take about 5 minutes. First one, remember I said there are 8 buyer contingencies? And remember paragraph 3 in the grid talks about the contingencies, and it talks about the loan contingency in paragraph 3E. And it says, remember the buyer has to say what type of loan they're trying to get. Because remember, if you want to back out of a deal based on a contingency, you have to act in good faith. So if my offer is contingent on getting a loan, I still got to tell the seller what type of loan I'm trying to get. And if I don't apply, if I qualify for the loan I want, then I can't use the loan contingency to cancel the deal. And remember, the purchase contract now gives the seller and the listing agent the right to contact the buyer's lender to see if they actually applied for the loan and what the status of the loan is. Bottom line is, here's the change. Up until a month ago, the buyer says, I'm looking for interest rate not to exceed blank, and I'm willing to pay only 0 points. So it defaulted to 0. Now the form says, I'm willing to pay interest rate not to exceed blank and points not to exceed blank. So it doesn't default to 0. You can still write in 0. Second change, I already mentioned it, the controversial new paragraph 3G3 that you're not going to use most of the time. Third change, paragraph 3M3. Interesting situation. You're buying a house. It's not occupied by the seller. It's not occupied. It's not vacant. It's occupied by other people, like tenants. As a buyer, you want those tenants to be out, don't you? Well, did you know there's no place in the purchase contract where you actually, up until now, where you actually say, if there are tenants there, they need to be out a week before close or whatever. So we have this addendum called the TOPA, Tenant Occupied Purchase Addendum. And we basically say right in the contract, buyer, if the property is occupied by tenants, you need to submit this form telling the seller when you want the tenants out, and also addressing the issue of what if the tenants are supposed to be out and they're not out? What are my rights as a buyer? I've removed all my contingencies. I'm getting ready to close and there are people still there. Do I have the right at this point in time to just cancel the deal and get my money back? Do I have the right to delay closing until they're out? Or is my only remedy to just close and deal with it myself? That's not addressed on the purchase contract. That's another reason why you should have the TOPA form. What we've noticed is a lot of buyers are not using this form for some reason. Maybe because they don't know who's on the property. So here's the new thing. It now says in 3M3 seller, you need to disclose in writing to the buyer who's living in the property and when they're going to leave. You're basically saying if the buyer didn't give you a TOPA, you should give one back to tell the buyer what's up. You know what the latest problem in this society is, you're probably aware of, is sometimes there are people living in the house who aren't sellers and they're not tenants. But who the heck are they? Adult children. Now, by law, when a seller leaves, they have to take their minor children with them. How do you like that? But when you got a 35-year-old kid living there, you're not a kid anymore, and you get ready to close and he's still there. He said, what are you doing here? He said, no one said I had to leave. I'm not a seller. I didn't say seller had to leave. I'm not a tenant. I'm not leaving. Which is why this new section says seller has to tell the buyer about anybody who's living there. Anybody over the age of 17 who's living in the house, you've got to tell the buyer because the buyer might not know. And you also have to say when they're leaving. And now I've got really good news. Even if this doesn't convince the seller or the buyer to use the TOPA form, there's a new paragraph 7A, which says, basically, if there's no TOPA form, both sides agree the property will be vacant at close. Now that I told you that, you're probably saying, well, good, I don't need the TOPA form. I still like that form to resolve the issue of what are the buyer's remedies if the property is not vacant. I'm always thinking it's a good idea for a buyer to automatically submit that form with every offer. Can't hurt, right? Just a thought. All right. Any other changes to the purchase contract you should know about? Well, there's a new paragraph 11M I already told you about. That's the new solar disclosure form. 3 more things, really simple. One of these you're going to laugh at. On paragraph 9, when it lists what comes with a house and what doesn't, it says, among other things, it says window coverings are included. And then it says in parentheses, window coverings includes draperies, curtains, blinds. But you know what it doesn't say? Curtain rods. You're not going to believe this, but some sellers have actually said, well, I'll leave the curtains, but I'm taking the curtain rods because it doesn't say I have to leave the curtain rods. You'll be happy to know there's been a change. It now specifically says the curtain rods come with the house. By the way, I say I have 12 questions. Don't leave. I'm going to do those questions. There's also a slight change. It says, you know how no deadline in this purchase contract can end on a legal holiday, weekend or a legal holiday? What the heck legal are we talking about? Federal holidays, state holidays? What are the legal holidays where a deadline cannot occur on? And the answer is, it now says in paragraph 25I, the definition, the legal holidays that we're talking about are the legal holidays listed in California Civil Code 7 and 7.1 and Government Code 6700. So you actually have to Google. If you look on your calendar and you see there's a deadline and you see it's this holiday that has some holiday you never even heard of, you're wondering if that's the legal holiday that affects contracts, you need call the hotline, we'll tell you, or just Google. I know what you're thinking. Why don't you just list them in the contract? What are the legal holidays? Because they keep changing, that's why. So we did do that. And on the very last page, and hang in there for questions, on the very last page, where the agents, up until a month ago, there was a blank for the agent to write in their designated electronic delivery address. But what if that's blank? What if an agent doesn't give you the address where they want you to send documents? Well, one new form, if you're keeping score, this is new form number 9, is the DEDA, Designated Electronic Delivery Amendment. So if I'm the listing agent, I get an offer, or I'm the buyer's agent, I get an acceptance, and the agent didn't put in their designated address where they want me to send emails, I can send this form over and say, please fill this in, you left that blank. But here's even better news is, if you've noticed this on the last page of the contract, when you're filling it in, it used to be you'd only put your broker's name, broker DRE number, your name, your DRE number, your partner, etc. Now, have you noticed that it auto-fills not just with that information, but also with your address, email, and phone number? So you don't have to write in your designated electronic delivery address. You simply have to check a box that says, yes, I want my designated electronic delivery address to be the email above, to be the email address that's already supplied. Now, you could, of course, say, no, the email address that I want you to send stuff to is a different address. Maybe you want your transaction coordinator's email address to be the email address where documents are sent to. You could check a box and write that in. But you don't actually have to write in the designated electronic delivery address. It's going to, your offer or your acceptance is going to autofill, hopefully this is working, on zip form with an email address. You just have to check a box and say that's the one to use or not. Let me go to the questions. By the way, I'll stay as long as you want, but I know some of you are thinking of an hour here. All right, Dave. A seller client I have an escrow told me that they heard that California imposed an automatic 3.5% withholding tax beginning 1/1/23. Is that real? No, that's not real. If you want to email me, we can talk about it. Maybe I can get into it more to try to figure out. There might be something I'm not aware of, but an overall general no. Andrew, in the case of domestic violence, is the cost of the UD incurred by the landlord? Unfortunately, yes. But think about it. Anytime you evict a tenant for doing something bad, like not paying the rent or creating a nuisance, I mean, you think in all those cases, the tenant is the one they should have to pay the cost of me evicting them because I'm only evicting them because they did something wrong. Unfortunately, no, landlords have to pay that. Natalia, can HOA prohibit to rent part of my house as short-term rental? Thanks for reminding me to say that. Yes. HOAs have an absolute right to prohibit short-term rentals, whether you're renting out the whole unit or a part. Dave, if an HOA has a rule, HOA has a rule that you can't rent a purchase condo for the first 2 years of ownership. Yeah, fight that. They can't require you that you have to live there a certain amount of time before you can rent. Fight that. They can't get away. Jacqueline, what's the number of law for the mobile home park certification? That would be SB 869. Valerie, is MLS going to remove the BAC? Remind me what the BAC is. Do you remember what that is? The commission. I'm not sure. I mean, nothing's changed now for what I said. So I'm not exactly 100% sure, Valerie, exactly what you mean. I should know that. That's not the variable commission, right? Yeah, I'm not sure. The point is, no. At this point, nothing has changed. Anonymous person, SPQ is not required by law, but it's required by the Sierra contract unless it's countered out, correct? Great question. It's worth talking about for a second. I said a second ago, every disclosure form mentioned in paragraph 11 is required by law, except this new solar form. And the very smart person who knows this stuff is responding, well, Gov, technically, the SPQ isn't really required by law either. Yes and no. There are a bunch of mandatory disclosures that are created by separate laws that for your convenience, we've put onto one form. The first 10 items on the SPQ or on the exempt seller disclosure are mandatory by law. You can't counter them out. Like death on the property in the last 3 years. The point is they are required. You don't have to use the SPQ to disclose them, but unless you're going to make up your own form, I'm going to say, think of the SPQ as a mandatory by law form that you can't counter out. Now, you're right. All of the questions in the SPQ, starting with number 11, are not required by law. And theoretically, the seller could counter out. I've never seen, I hope I never see a seller trying to counter and say, I'm only going to answer the first 10 questions on the SPQ, because you don't want to do that. Answering those questions prevents lawsuits, protects you. So just do it, I would say. Okay, maybe this is the same anonymous attendee or a different one. What if you as an agent just want to negotiate the commission with the seller's agent? Can we still use the SCBC and keep it between the brokers? Yes, absolutely, good point. In other words, the new thing on the purchase contract is you basically saying to the seller, your agent is too cheap to pay me what I want, so I want you to make up the difference. But of course, you still absolutely have the right to not involve the principals and go directly to the listing agent and say, I'm worth more than the 2% you're offering me. I want more. Please sign my CBC. Pam, my friend, this follows up directly. I was always told we can't negotiate commission in the contract. And that's exactly what I was just saying. In other words, agents can't negotiate with other agents in the purchase contract. But this new thing is just simply asking the seller to pay something that was already negotiated. Just think of it as it's a credit. I just want the seller to pay something that I've already agreed to pay. Some of you could react to this by saying, how dare a buyer do that? They just agreed to pay their buyer's agent. Now they're trying to get the seller to pay it. They shouldn't be doing that. But that's a moral question. DRE says, once again, anonymous, DRE says that a licensee must disclose all compensation to be received in connection with license activity, or else you are in violation of secret profit. This would include compensation paid to a buyer, broker from a seller. That is the best question of the day. I agree with you. I've thought that for 37 years. I read the DRE rules the same as you do. I think a buyer's commission, if you don't disclose it, is a secret profit. So then why, you're asking, Gov, did you say a few minutes ago that under current law, the buyer is not required to tell, buyer's agent not required to tell their buyer how much they're getting paid? Because even though it says that in the regs, the DRE has never enforced that. And there's never been a lawsuit. I've been waiting for that for 37 years. I agree with you. I read the DRE regs the same as you do. I think buyer's agents' existing law requires it. But you know what? Buyer's agents don't do it, and they've never had any negative consequence for not doing it. Maybe that will change. Lisa, form letters on the last two forms. I believe, okay, the delivery of the designated electronic delivery amendment is DEDA. But I don't remember the last form. What was it? Maybe the BTA, the buyer transactional advisory. Remember, there's the 6 buyer broker forms. Then there's the solar advisory and the non-contingent offer advisory. Then there's the DEDA. And then there's the very last one, which I haven't even told you yet because I'm making you stay because I want to answer the questions, but hang in there. Natalie says she doesn't want to provide a designated delivery address. You don't have to. Okay, let me scroll down here. Cindy, can buyer request the forwarding address of seller after closing? You can request to your heart's content. The agent doesn't have to give it to you. This happens all the time. That I want to sue that jerk of a seller, or at least I want to complain to a listing agent. Give me their address. Listing agent, you don't have to. Yes, Jacqueline, that's the number. Valerie. Once again, Valerie, I still don't know what BAC means exactly, but I think nothing has changed. That's all I can say. All right, I think that's all the questions. Let me go to chat, even though you weren't supposed to go to chat. Some of you went to chat. So just to be fair, email address, govh@car.org. Tiffany gave you the good link there. Thanks, Tiffany. Cindy, you already asked that in the Q&A. I think that's it. Okay, there is one more form. The only thing I haven't told you is, I mentioned in passing, is there are some changes to the property management form, the property management forms. If any of you do property management, right? You happen to do property management. We have a property management agreement, we have an application, we have a lease. All of those forms were tweaked. I don't have time to talk about them, nothing too crucial. But there's one new form, which is my 10th and final new form of the day. The RPOD, Rental Property Owner Disclosure Form. You know when you sell a house, there are all these disclosure forms you got to give the buyer. What about when you lease a house? Are there any disclosures you have to give the tenant? Yeah, but they're all on the lease form. But if you're a property manager filling out a lease form for your client, the landlord, you don't know how to fill in those blanks. Like, I mean, the things I have to disclose on the lease form, I have to ask the owner, the seller, my client, was there any lead paint on this property? Was there any meth on this property? Did someone die in the last 3 years? You got to ask them, are there bed bugs? These are mandatory disclosures, but you filling out the form on behalf of your landlord client, you don't know. So I'm sure informally, those of you that do property management have always been asking your clients for the information so you can put them on the lease. Now there's a nice formal document that you can give to your client and say, please answer these questions so I can fill out the lease for you. I just found out from the forms committee that they're going to, even though that's a brand new form that just came out a month ago, in June, it's going to split into two forms. One part is the form you're going to give just to your landlord, and they're going to give information. The other part is stuff that you're going to give directly to the tenant. People have said, why don't we just give this form directly to the tenant? Because there's stuff on there that is between you and your client that's really none of the tenant's business. But there is some stuff on there that is part of the tenant's business. It's going to be on the lease, but the forms committee just decided, maybe it'll happen before June. There's going to be two versions of this new form, but right now there's only one, and don't give it to the tenant. Okay, I see Tracy. Does the max 10% increase apply to single family owners not living on the property? If you're talking about the maximum increase in rent that you can charge to people, remember there's the rent gouging laws, but that's going to be over. Something that people think it's over now. To be conservative, you wait till the end of the month. So if your property is a single family home, right? Unless you're in Los Angeles, if you're in a single family home, you can, and the anti-rent gouging laws don't apply, you can increase the rent by more than 10%. If that's what you're asking. If anyone wants to unmute yourself so I can talk to me, if that's easier. Unless Brian wants us to go away and stop talking.
I don't think folks have the option to unmute.
Oh,
so
okay.
We're stuck with the Q&A.
All right, then you guys all have my email address. Email me, and you have the hotline's quicker, by the way. I mean, if you call the hotline, you'll get through in 5 minutes. If you email me, it'll take a day or two. But we're there for you about all these forms, all these laws. Okay, Andrew has a question. When leasing, we offer a cooperating broker commission in the MLS. On multiple occasions, the tenants has said I should read that out. When leasing, we offer a cooperating broker commission through the MLS, and on multiple occasions, the tenant's agent has had their commission withheld from the move-in and had it paid directly to them. Okay, I'd have to think about that one for a second. I got to look at the rules on that one, on leases. It sounds wrong. You're right, Andrew. I'd have to look at it. Please, Andrew, email me or call the hotline, and I will definitely answer that question. Any more?
One more here came in from 59B Mike.
Is that in chat or Q&A?
Q&A, very end.
Oh, okay. I don't see it.
It says, why isn't the SPQ combined with the TDS to have just one form?
Great question. Why isn't the TDS? Because the TDS, believe it or not, is a statutory form. Every word on the TDS appears exactly like it does by law, whereas the SPQ is a totally created by us form to assist you in doing all of the other mandatory disclosures that aren't included on the TDS. So, which begs the question, why don't we sponsor a law where we increase the TDS to add all the questions on the SPQ? And I think there are two reasons we don't want to do that. Number one, there's always new stuff coming in. We don't want to have to go to get a bill passed to add the new disclosures. And second, we've always had this philosophy, we never want to change the TDS unless we actually have to. Because once the TDS is on the table, some legislator is going to add stuff we really don't want. So as long as it's not part of the legislative process, it's not brought up, it's hard. It seems to be less likely that legislators create new disclosure laws. But if all they had to do is change the TDS, we're scared about changes that would happen. So whether we're right or not, that's but the other reason I think is even more important. Tiffany put in the legal hotline. That's good.
Joe, did you answer this question about the NAR no longer permitting agents to hold other agents' listings open?
Okay, good question. It's DRE and they backed off. DRE gave a webinar early last year, where the commissioner said you shouldn't do open houses for other brokers. He made it sound like it's almost like it's illegal. They backed off. They're saying, oh, we're not saying that. What we're saying is you have to understand that you can only do licensed work for your own broker. When you're at an open house and you're talking about the property or showing the property, that's licensed work. The only point being, if you're sitting in if you're quote unquote doing the open house, but it's not your company's listing, when people come into the open house and you start talking to them about real estate, you have to make it clear to them, you are not the listing broker. Any information you're giving them, any advice you're giving them, you're not giving it to them as the seller's agent. You're giving it to them as a potential buyer's agent. So it's almost like if you're going to do an open house for someone else, you should bring your own, maybe your business card, but maybe better than that, a flyer of some kind, just demonstrating very clearly on it. You're going to give it to everyone you talk to, make sure they understand when they come back later and say, what did that agent tell me again? They're going to realize that they were not talking to the listing broker. They were talking to just you, a potential buyer's broker, to get liability straight and disclosure straight. Because it's been causing problems, people getting sued. I mean, sometimes the listing broker gets sued for what the buyer's broker said and vice versa. E&O, there've been E&O issues. As long as you make that distinction, though, I think you'll be okay. Tiffany put my email address again. Believe me, realtors don't hesitate to email me on Saturday night. It's funny how that works. So,
you see the
I'll respond. That's even funnier that I'll respond sometimes on Saturday night.
You have the other two questions there, Gov?
I don't.
Okay. Does the outside broker / agent need to get the seller's permission to do the open house?
I would say there's nothing that says that in writing, but I would say strongly, in my opinion, listing broker, you need to tell your client that someone who's not in my office is going to be holding your house open. I personally strongly believe that.
And then another question, you said to view the SPQ as mandatory, and then it says even with the ESD.
If I said that, I didn't mean to say that. It's one or the other. Most deals you do are going to involve the TDS and the SPQ. But if you're doing a probate sale, an REO sale, a bankruptcy sale, or a trust sale, unless the trustee used to be on title personally, there is no TDS and SPQ, but there's an ESD instead of that. So every deal you do on 1 to 4 property is either going to be TDS and SPQ or just ESD. But remember, in all of these cases, you got to do your add. There's no exemption for a realtor to do an inspection and an add. Eddie, as far as a form from the seller, we don't have a form. I would get it in writing, though, that the seller is permitting you to have someone who's not in your brokerage do the open house.
All right, Gov, I think you've answered them all. Thank you very much, Gov,
Yeah.
for the presentation.
Sorry about last Thursday.
Very enlightening. We appreciate it very much. And thank you also for your email address, your phone number, and being available for us. We appreciate it. So thank you. Thank you to your team and for all you do for us. And thank you, everyone, for attending.